Hello and welcome to Rights of a Free People, a program of the Rhode Island affiliate of the American Civil Liberties Union. I'm Dan Weissman, a volunteer at the ACLU and host of this program. Check your calendar and you'll see it's July, which means it's time for our Supreme Court review. And speaking for myself, I'm really glad they're done. We will see what our guests have to say about that. Starting closest to me, Richard Sinapi. Richard is an old-timer on this show and threatens to take over from me whenever the urge hits him. And principal of Sinapi Associates.
Sinapi Law Associates, correct. Yeah.
In Warwick.
Right.
John Marion is director of the Rhode Island Common Cause.
Correct.
Also an old-timer on the show. We had this crew last year this time. And maybe we have better news than we did a year ago. That is yet to be seen. So the ACLU office took a look at the cases the Supreme Court decided this term with, of course, the lens of civil liberties. And we have 5 cases we're going to review, sprinkling in maybe some anecdotal information along the way, a local flair maybe. So we're going to start with the American Legion case. This came out of Maryland. The vote was 7-2. And Dick, you won the toss, so you get to go. What happened? What was it about? Are we happy with the results?
Well, as you said, it was a 7-2 decision where the Supreme Court held that a 40-foot Latin cross erected in a busy intersection on public land in, I think, Bladenburg, Maryland, did not violate the Establishment Clause. It was also maintained by the Maryland Parks and Recreation. They actually, I think they took over the maintenance from the original group that erected it, which was the American Legion. It was technically, I think, a negative from civil liberties standpoint in terms of holding back establishment of religion, but frankly, I don't see it as a grave departure. First of all, I don't see any departure from past precedent. Second of all, I don't really see it as really an inroad against civil liberties, and I'll tell you why. The Supreme Court's reasoning, I think, is consistent with past precedent where it has upheld certain religious symbols where they have taken on secular meaning. And to me, that's basically what this case is. Keep in mind, this cross was erected in 1925. Here we are almost 100 years later. And this cross has taken on a symbol beyond any religious purpose. It reflects the sacrifice of fighting men and women.
World War I, right?
World War I. It's used to indicate gravestones, grave markers, not necessarily with any religious significance, but in a reverence for the deceased. So it also pointed out that that use of the cross was a part widespread around World War I time. They had departed from the normal practice of using rectangular slabs to mark soldiers' graves, and they started going with a cross. And so this took on basically the design or of the time that was used. So the court also pointed out that throughout history, the Red Cross has a cross as a symbol, totally secular organization, has no religious intent or connotation. So similarly, the court said, over the passage of this much time, who knows what the original intent was? Was it to applying the Lemon test? Does it have a secular purpose? Test 2, is its primary purpose or effect to advance or inhibit religion? And step 3, whether or not it results in excessive entanglement. They said, it's hard to even apply the test because who knows what the original purpose was. But we believe now that it's taken on a secular meaning in terms of reverence, recognizing the sacrifice of soldiers, and it has in other aspects of our society taken on secular meaning, and therefore we allow it. I'll say one final thing about it. The court cautioned, we note that this was erected, almost 100 years ago. we might have a different opinion if basically saying we might have a different opinion if somebody tries to erect a 40-foot cross, in Times Square and say it's got secular meaning. So they did point out that how long it's been there, and that by being in there that long, it has taken on a secular meaning, and the original purpose lost.
What did the dissenters say?
Pretty much, that the symbol has originally had a religious purpose, and that it continued. And of course, they disagreed with the taking on the secular purpose as being, a slippery slope under the Lemon Test.
Oh, okay. So Lemon Test stands.
That's my reading of it.
For another day.
That's my reading of it. Yeah.
Yeah. Okay. Well, maybe we'll come back and explore this a little bit, time permitting. Let's move on to the citizenship question. This one got a lot more, I think, ink around the country and maybe some stronger feelings. It was a 5-4 decision. John, you guys were, as Common Cause, you were a participant in.
So I think we signed on to an amicus brief. We were the plaintiff in the gerrymandering
okay,
case.
So we'll come to that. So
yeah.
you were involved, but not a litigant.
Yeah. So this is the one about should the citizenship question be asked on the census, and it was a suit by the state of New York against the U.S. Department of Commerce, which runs the Census Bureau. It was consolidated, I think, with another case where some civil rights groups had also sued the Department of Commerce. And it was 5-4, Roberts, the Chief Justice, writing the majority opinion. But it was pretty fractured. And ultimately, the holding was that it's going to be remanded back to the district court. So it's not a clear victory that the citizenship question is off the census. The district court could find that the Census Bureau has another reason for putting the question on and allow it on. We don't think that district court judge would do that, but there's some debate about there are other routes that the government could take to still try to get the question on. But it came down actually not to a constitutional issue. It came down to a question of administrative law. So New York had sued saying that putting the citizenship question on the census violated 3 things. It violated the enumeration clause of the Constitution, the requirement that everybody be counted. It violated a law from the 70s called the Census Act, which explained how the Census Bureau was supposed to go out and conduct the census, and that it violated the Administrative Procedures Act, which governs all administrative agencies in the federal government and how they make decisions. The court, the conservatives on the court said it doesn't violate the Constitution, it doesn't violate the Census Act, but Roberts sided with the liberals to say it does violate the Administrative Procedures Act. And the hurdle there was that it was, in his words, but the hurdle is that it requires a reasoned explanation for including the question on the census, and that, in Roberts' words, it seemed to be not a reasoned explanation, but a contrived explanation. So,
in other words, government, you're lying.
Yeah. So Secretary Ross from the Department of Commerce said that the reason he wanted to include it was so that the Department of Justice could better enforce the Voting Rights Act. That they needed citizenship data to better protect people's civil rights. But what the record found, and what the majority agreed with, was that wasn't the reason. Right? The reason was to drive down participation in the census. That was just pretextual. That Ross, the record showed, had gone around fishing to different departments in the federal government and said, "Can you give me a reason? Can you give me a reason?" And he got to DOJ and they said, "Sure, we'll give you a reason." And that was the only reason he cited in doing it. And DOJ even admitted, well, they don't really need this data in this form to enforce the Voting Rights Act. They've been enforcing the Voting Rights Act for 50 years using data that came from what's called the American Community Survey, and prior to that, the long-form census questionnaire. So yes, so Roberts essentially said, Trump administration, you're lying. But what he did is he sent it back to the district, or they sent it back to the district court. And presumably, Department of Commerce is going to offer another reason. And there's some belief that the court may come back in a hurry in September and say that's a good enough reason, you can put it on there. One last thing is, though, that the government argued all along that a decision needed to be made, right? This skipped the Court of Appeals. It went straight from the district court to the Supreme Court.
So they could print the forms.
So they could print the forms by starting July 1st. And so the government said that all along. And now the question is the government going to say, well, we can put it off past July 1st, so we'll see.
Okay, that I hadn't heard. So the door is slightly ajar.
The door is slightly ajar. The chief scientist of the Census Bureau said with an extra appropriation from Congress, they could go as late as October.
Oh, so we may see a re-review.
Yeah, so there's a couple of options, as I understand it. There's sort of like a duty justice during the summer. It could go up to them. Or it could even be argued, in September and decided in October, and they could print the forms then. So it seems like the legal community is pretty split on whether this is a true victory or not. But temporarily, it's a victory for not including this question, which is a victory for what I think is, and my organization thinks, is the true constitutional purpose of the census, which is to count everyone regardless of citizenship status.
And the motivation, the government's motivation that came out in all this was to suppress minority people's voting.
Yeah, in fact, late after the oral arguments, Common Cause received some material from the estate of the man who came up with this idea of asking this to suppress. A man named Thomas Hofeller, who is a Republican redistricting strategist. He passed away. His daughter got all of his hard drives and thumb. She handed it to our North Carolina office. They went into the hundreds of thousands of files, and they found a letter where he says you should ask the citizenship question. That will depress Latino turnout. It will help whites and Republicans in elections for the next decade.
We need to move on. The time is going quickly. Dick, what is the Eighth Amendment? I don't remember from high school what the Eighth Amendment says. And what's the Timbs case?
The Timbs case was actually a unanimous decision, and it was a pro-civil liberties ruling. And the court held that the Eighth Amendment, the excessive fines clause, applies to the states through the 14th Amendment, through the process called incorporation, which, because the original, Bill of Rights only was a limitation on federal action, it didn't really apply to the states. And once the 14th Amendment due process clause, which does apply to the state, was passed, they solely incorporated many of the rights of the Bill of Rights. Matter of fact, pretty much all of them. Now, the Second and Eighth are in, have been incorporated into the U.S. Constitution in terms of application to the states. Now, in that case, and what it says basically is, I try to paraphrase, is that neither excessive bail will be required or excessive fines imposed or cruel and unusual punishment inflicted, basically, is what it says. And in that case, just to give you the facts, an individual, I think it was a first offense, was found to be charged with possession of a controlled substance with intent to distribute, and I think conspiracy to commit larceny. So the maximum fine for that was $10,000. The government in that case, which was the state of Indiana, sought to forfeit his brand new $14,000 Range Rover, which he bought with insurance proceeds from a deceased parent. to forfeit that in what they call an in rem proceeding because it was used to transport the contraband supposedly. And they raised, the excessive fine clause and said, look it's a $10,000 fine is the maximum. You're doing something that's 4 times that with a $42,000 car. And interestingly, the trial court said that, the appellate court said that, the Indiana Supreme Court said no. They said, no, it's never been incorporated, and we're not going to do it. Well, they're right, it wasn't ever incorporated, but there's actually prior decisions of the Indiana Supreme Court suggesting there's proportionality either in or can be interpreted from the Indiana Constitution. Anyways, it went up on appeal, and it was a unanimous decision. And interestingly, the court said, look this concept of fines, it goes back to the Magna Carta. It was improved, new and improved in the Bill of Rights. I mean, the English Bill of Rights, okay? It was in the colonial era constitutions, state constitutions, even before the U.S. Constitution. And now, all 50 states either have an excessive fines clause or a proportionality provision. So, does this pass the test, for incorporation? Is this right fundamental to our scheme of ordered liberty, or is it deeply rooted in the nation's history and traditions? Yes. The facts are clear. Civil liberties win. Kind of an easy slam dunk, in my opinion.
Good, because we have a kind of shortage of those victories. Moving on to my favorite, the gerrymandering case, because I have a particular aversion to the whole gerrymandering trend or tradition. John, what happened?
Yeah, so this is a case where Common Cause was the plaintiff in a case out of North Carolina. It was combined with a case out of Maryland, where actually the plaintiff was a former board member of Common Cause in Maryland, so we were involved in both cases. And the question before the court was, is it against the U.S. Constitution to have extreme partisan gerrymandering, meaning to pack people of one political party, and in the case of Maryland, it was Republicans. In the case of North Carolina, it was Democrats, to pack them so much into districts as to create an advantage for the other political party in the state. And in both cases, it involved congressional seats, but it's a practice in state legislatures too. And the answer from the court, again, 5-4, Roberts and the conservatives, was, yeah, this is actually a problem, but we're not going to do anything about it because it's a political question. It's beyond the reach of the court to solve this. And it was interesting that they were willing to acknowledge that it was a problem, but they, after really about 25 years of Justice Kennedy toying around in a series of opinions where he said, this is a problem, bring me a standard in which we can solve this problem. Once Kennedy retired, they just closed the book and said, this is a problem, it's a political question, we're not going to touch it. There is no standard that in our mind is clear, manageable, and politically neutral. End of case. So, and what Robert said at the end is, go turn to the states. Let either the state courts do it under state constitutions, like has happened in Pennsylvania. Let it happen where state legislatures do something about it, or have citizen referenda or initiative take care of it. The interesting thing is, there was a case about 3 years ago where Roberts sided with the conservatives to say about the Arizona Redistricting Commission, which was created by initiative, you know what, that violates the Constitution. So I think a lot of people think that in 2 or 3 years, there'll be another case where Roberts is going to say, well, the states can solve this problem, but we're going to take away one of the main tools for solving the problem that 50% of the states have, which is citizen initiative, because that violates the elections clause of the Constitution. So this was just absolutely a loss for a common cause, from the ACLU's standpoint, for anybody who wants to do anything about partisan gerrymandering. The thought now is that when legislatures do this, they're going to stand up and say, very proudly in public, we are trying to partisan gerrymander the other party, and that's a get out of jail free card. Even in states where race and party correlate, and it might be racial gerrymandering like North Carolina or many of the southern states, as long as they say, no, we weren't doing racial gerrymandering, we were doing partisan gerrymandering, they have a get out of jail free card. So this could not have been a worse outcome. Prior to the decision coming out, people thought maybe Roberts was going to try to come up with a sort of a narrowly tailored decision here, but he closed the book. So it's going to be a generation before we can tackle this problem at the court.
I was very disappointed. I did read that Common Cause is less pessimistic as they move to state courts, and they did say North Carolina they thought they had a pretty good shot.
Yeah, so there are, I think it's 16 states that have clauses in their state constitution, free and fair elections clauses. And Pennsylvania last year ruled that essentially that is enough to throw out a set of maps that are partisan gerrymandered is inhibiting a free and fair election. Unfortunately, Rhode Island's not one of those states. So we don't have a free and fair election clause in our state constitution. We don't have citizen initiative, but we do have partisan gerrymandering. And so if anything's going to be done about it, it's really going to have to come through the legislature, who has the most sort of vested in it. The tagline about this is, and as Justice Kagan says in her dissent, a really good dissent, this is politicians picking their voters, not voters picking their politicians. And so this is a big blow to democracy.
Let's move, with time running out, let's move to the double indemnity, not double indemnity, but dual sovereignty. What went on here, and are we happy with the results?
All right, you're referring to Gamble v. United States. That was a 7-2 decision, and the court ruled that the dual sovereignty doctrine did not prohibit or did not allow a defendant to raise a criminal prosecution in the federal court as a bar based on double jeopardy grounds in a prosecution in the state court. And therefore, it was obviously a negative civil liberties determination. It was, again, a somewhat limited one. It was well-grounded in precedent, well-grounded historically. The double jeopardy clause, from its inception, was always interpreted and designed to apply to offenses. Not the same conduct, offenses, a certain offense. So an offense under federal law is different than an offense under state law. In this case, it was possession of a firearm, convicted felon, I think, being possession of a firearm, I think, was the offense. It was the same under both, but it was a state offense. The conduct was the same, no question about it, but one was a federal offense, one was a state offense. And they went into the history and the text and the fact that there is quite a body of precedent that says that the double jeopardy clause, the dual sovereignty concept, does apply in the double jeopardy context. So while it was not, it was a negative civil liberties determination, I don't think it was, again, it didn't retract on existing civil liberties. It is well grounded in precedent. It probably has limited application. However, the concept, unfortunately, is the same. It allows the sovereign to oppress an individual. And if they really want to convict somebody, there's many ways to do it. And if you could do it on the federal level and not succeed, and you do it again on the state level, at some point, the power of the government can overwhelm the individual. And that's really the concept behind it. Fortunately, there's not a lot of cases where the feds and the states are necessarily going to collaborate on some offense, some oppression of an individual, but that's really the underlying civil liberties concern.
Is there any relevance to the possibility of a presidential pardon followed up by states? Basically the same behavior or same offense?
Interesting, because I believe that there's a discussion about that with the sitting president if that were to happen. As far as I know, it's never been really tested, but a president can only pardon somebody under federal law and cannot pardon somebody under state law, would be the precedent and interpretation.
And
right
this
now, for the
decision,
same concept.
now, does this decision shed any light on what might happen in that circumstance?
I think it reinforces that interpretation because of the dual sovereignty concept. You can pardon somebody for all offenses under federal law, but that same conduct might be a violation of state law. Well, you're not pardoning somebody for their conduct, you're pardoning somebody for potential offenses under federal law. So yes, I think that the reasoning in this case could be used to say that a federal pardon would not apply to a state prosecution for the same conduct.
1 minute left. My question every year: give the Supreme Court a civil liberties grade. If I remember correctly, Dick is not a very generous grader. I remember John maybe being a little more giving. What do you say?
I'd say probably a C.
A C, which I think is maybe grade inflation from last year.
No, it's a C. I mean, the only reason why it's not lower is because two of the negative civil liberties determinations didn't roll back civil liberties, and were well based in precedent, and were very, I think, limited in their impact in the future.
John?
Yeah, I almost want to give an incomplete, right? Because the citizenship decision is incomplete. But if I had to grade, I do grade a little better. I think it's a B minus. I think we're right that these weren't particularly hard ones for them, to incorporate the 8th Amendment. Well, you'd pretty much incorporated the other 9, so it's not hard to do that. But this isn't a bad outcome necessarily. It could be. I think the grades will be much worse in years to come.
And yeah, I have the same fear with some of the analyses I've read, that they're positioning themselves, particularly Roberts, to come down a little heavier next year.
Well, interesting if they're going to do the only solution to it. Will they galvanize the electorate? Will they galvanize people to use their vote? Because that was the challenge in that case, Rochu, right? Rucho. That was the challenge. We're not going to do it. Yeah. That's a political question. So now you're going to galvanize the people. Are you going to galvanize the electorate to make it to change? Because that's the only way you're going to get a change. And if the Supreme Court does inroads on civil liberties, the only way you're going to change it is through the election box.
So if you feel like being galvanized, call the ACLU, call Common Cause, call Snappy Associates, and we'll help you get galvanized. Thanks so much. It's always a pleasure to do this program. Dick Snappy from Snappy Associates, Warwick, and John Marion, Common Cause. Thanks so much.
Thank you.
And thanks for tuning in. See you next time.